License and registration, please.
Of course, officer. Right here. You seem a little on edge tonight. Is there any reason you were going 5 miles under the speed limit?
No, sir. Just tired. Heading home after a long day.
I see. I'm gonna ask you to do me a favor. Please step out of the car.
What do you do now? Do you know your rights in this exact moment? Can this officer frisk you without any warrant? You might think the Fourth Amendment is your shield, but what if that shield has a loophole? A loophole that gives this officer the power to search you if he can point to specific facts suggesting you're not just nervous, but potentially armed and dangerous. Most people get this wrong, and the consequences can be life-altering.
In our last video, I asked you what legal myths or cases you wanted us to tackle next. I read every single comment, and one stood out. A viewer asked us to break down the case of Terry versus Ohio and its impact on your rights during a police encounter. You asked for it. So today, we are breaking down the controversial case that created the Stop-and-Frisk, a case that truly tests the limits of the Fourth Amendment.
It all started in Cleveland, Ohio in 1963. Detective Martin McFadden, a 39-year veteran, was patrolling downtown when he noticed two men acting suspiciously. One of them was John Terry. Terry and his companion would pace back and forth, repeatedly staring into the same store window before meeting up with a third man. To Detective McFadden, their behavior screamed casing a job, a stick-up. To his trained eye, this was more than a hunch. It was a pattern, specific articulable facts that were building towards reasonable suspicion. McFadden confronted them, identified himself, and frisked Terry. He felt a pistol in Terry's breast pocket. Terry was arrested and ultimately convicted of carrying a concealed weapon. His lawyer fought back, arguing that the gun was found during an illegal search. The case went all the way to the Supreme Court. In an 8-1 decision, the court sided with Detective McFadden. They ruled that his actions were constitutional because it was reasonable to suspect the men were armed and dangerous. In doing so, they officially created the Terry Stop, a powerful tool that fundamentally changed American policing. To understand why this case is so important, you have to understand two different legal standards. First, there's probable cause. Think of this as a high bar. Police need solid facts or evidence to believe you have committed or are committing a crime. This is what's required for a warrant or a full arrest. But the Terry case established reasonable suspicion. This is a much lower standard. It doesn't require proof, only specific and articulable facts that would lead a reasonable officer to suspect that criminal activity is afoot and that the person may be armed and dangerous.
But here's where it gets complicated in the 21st century, the Second Amendment. What if you are legally carrying a firearm? Does that fact alone create reasonable suspicion? Federal courts are deeply divided. For example, the Sixth Circuit Court ruled in Northrop v. City of Toledo that legally carrying a gun is not enough to justify a frisk. But the Fourth Circuit ruled in U.S. v. Robinson that officers can frisk someone they lawfully stop if they suspect they are armed, even if it's legal. It's a legal clash happening right now.
So, if you find yourself in a situation where an officer wants to pat you down, what do? This is not legal advice, but here is a general framework based on these legal principles. Your goal is to remain calm, compliant, and clearly assert your rights.
Step 1. Clarify your status. Ask the most important question calmly and clearly.
Am I being detained or am I free to go?
Step 2. Comply physically, but do not consent verbally. If the officer states they are going to perform a pat-down for safety, do not resist physically. However, you must state your position for the record.
I do not consent to any searches.
Step 3. Invoke your rights. After the initial exchange, the rule from our Miranda video applies. And while Miranda warnings are technically only required once you are in custody, your right to remain silent can and should be invoked at any point. Staying silent early protects you either way.
I am going to remain silent, and I want a lawyer.
The Fourth Amendment protects you from unreasonable searches. The Supreme Court decided in Terry v. Ohio that a limited pat-down based on reasonable suspicion is not unreasonable when officer safety is a concern. The line between suspicion and proof is thin, but knowing where that line is drawn is your best defense. This case highlights the ongoing tension between individual liberty and law enforcement authority. What other common police interactions or legal doctrines do you find confusing? Share your thoughts in the comments below, and we may cover it in a future explanation.